Good afternoon, everyone. Welcome to our planning lives this afternoon. And today we're going to look at the CMA market study into house building. So straight off, we're into new acronym territory for a lot of us. CMA being the Competition and Markets Authority. And delighted to welcome colleagues from various sectors of the business to discuss that. And that's, I think, what appealed to us in picking this topic, that although it's very relevant to the planning system, it's coming from a much wider context. A lot of people will have seen reference to this in the press and maybe thought, I wonder what that's about, and not had a chance. So this is your chance. Today, we've got a planning lawyer, a competition lawyer, and a real estate lawyer, but instead of them walking into a bar, opportunity for a joke, but not going there, they're going to be guiding you through what the study actually says, the implications, and just providing thoughts from their individual perspectives. So to introduce colleagues properly, Charles Livingstone, one of our partners, he heads up our competition law team. So he's going to explain all the CMA stuff, thank goodness, because I certainly need that explanation. Elaine Farquharson-Black, familiar to the Planning Live audience, one of our planning partners, also head of our house building team, so this is very relevant to her work. And then Fiona Dromgoole, managing associate in our house building team, and heads up our plot sales team, so she's got some thoughts on some of the aspects of the study that relates particularly to those aspects of house building. So kicking all of this off, as I turn my page, Charles, maybe if you can do a bit of background scene setting, just tell us, well, what is the CMA? What is a market study? Why did the CMA actually embark on this study?
Sure. So the Competition and Markets Authority is the UK's competition regulator, and it has a few different functions. So it handles merger clearances, it investigates potential breaches of competition law, and then it also does consumer protection and a number of other things, but it also has the power to carry out market studies and market investigations. And a market study is something that the CMA does to look at the operation and the features of a market to consider whether there are problems in how that market works that might have an adverse effect on consumers, and in particular if there are features of the market that inhibit the proper working of competition. And if they do identify those, then they can identify steps that might be taken to remedy problems. So they use this tool where there appear to be issues in a market, but those issues are not necessarily due to the conduct of individual players. It's not that competitors are fixing prices or somebody has a dominant market position and is abusing it. Those are the sorts of things they can use their enforcement powers against. A market study is looking more at structural issues, how people are incentivized to behave, and very importantly for our topic today and our context, if there are regulatory issues that are inhibiting, possibly for good reasons or possibly just as an unintended consequence, are inhibiting the functioning of competition within a market. So why house building? Well, this study was it was at least prompted. I think it may have happened anyway, but it was prompted by Michael Gove, the Levelling Up Secretary of State in the UK government, who wrote to the CMA back in 2022 and suggested that while it's a matter for the CMA and all that bureaucratic language, that it might be a good idea for the CMA to carry out a market study into house building. The last one was back in 2008. His letter noted that there had been changes since in how the market works, in demographics, and indeed in policy. And he had a particular desire to understand if there were barriers to SME entry and expansion in the market, including in the land market. So that's the market to actually buy land, and the planning system. Now, to a large extent, I think he's probably pushing at an open door there, because the CMA's current focus is very much on areas of essential spending and financial pressures for consumers, and that includes accommodation more broadly. So they're doing some consumer protection work in relation to leaseholds in England, for example. So that's how we got to a study.
Okay, and the CMA actually undertaking the study, could you give us a bit of an outline of the steps they took, which has resulted in the report?
Yeah, so when the CMA kicks off a market study, it always sets out a proposed scope of what it proposes to look at. So essentially identifying here are the things that, although we haven't yet done the work, we suspect are worth looking at and are potentially contributing to whatever dysfunction it is they think is present in the market. So that kickoff was back in February last year, 2023, set out a scope that included investigating not just the construction and sale of houses, but the process of securing land and securing planning permission. And in particular, they set out that the scope would cover Scotland and England and Wales. Now, they don't always do that, particularly where you have one part of the UK that has different regulatory frameworks, for example. So they might have decided to exclude Scotland because it's a separate planning system. You have different rules on tenure and that sort of thing. But they did it on a GB-wide basis, which is obviously good from a Scottish perspective, because it means they looked at the Scottish market as well. Now, at the outset, they identified 4 key areas that they wanted to look at. First one was housing quality, including whether there was effective competition, whether there were barriers to entry, and also the management of estates, which we'll come back to. The second one was land management, including land banking. The third one was local authority oversight, including affordable housing policies. And the fourth one was whether there were factors in the market that limit innovation. So having set out that scope, they then went about gathering information. They have significant information gathering powers when they do a market study. So they were able to and did require the provision of information from key market participants, but they also had an open call for input, so inviting anybody who was interested to provide information or views. The window for that was actually quite short. It was only about 4 weeks. And that was part of their initial consultation. So they consulted on whether the scope of the study was right, but also at the same time said, send us your comments on the substantive issues we've identified in our scope. So, it was all, it all gets off to quite a fast start. The CMA then has 6 months to consider the information it's been provided with and confirm whether it's inclined to move to phase 2 of its process, which is a more detailed market investigation. And the big difference between a market study and a market investigation is if the CMA moves to a market investigation, at the end of that, it has the power to impose orders. So it could make orders requiring particular changes or requiring businesses to behave in a particular way. So if we have anybody on who's in the sort of the groceries retail sector, both the groceries code and the controls on land banking that apply to retailers, those came out of the Competition Commission, the CMA's predecessor, but came out of a market investigation. So they consulted in August on a proposal to make a market investigation in respect of 5 features of concern. 1, land banking again. 2, private management of public amenities. 3, complex and frequently changing, as they described it, planning rules. 4, market competition, especially challenges for SMEs. And then 5, barriers to entry and expansion, in particular with an SME focus again. They then produced some working papers in November setting out their what they'd been up to on land banks, and in particular they focused on specific geographic areas that they'd identified as possibly having quite a high concentration of land in the control of builders who were not building it out. Neil's had working papers on the planning system and on estate management. And then things went a bit quiet, and then we got the final report in February.
So quite an extensive process, really. And you've kind of taken us through the background, sort of the why and the how. So actually looking now at what the final report says, can you take us through the issues that the final report identifies and the solutions that they're suggesting?
Yep, I can do. So the report uses the phrase fundamental concerns with how the market operates, but notwithstanding that, and notwithstanding them having consulted back in August on making a market investigation, they are not making a market investigation. So they're not going to be doing further, well, they're not going to be doing that big formal exercise, and they're not going to gain the ability to issue any binding orders. So it was a little bit of a surprise given that they had consulted on, as I said, 5 areas where they thought a market investigation might be appropriate. That market investigation is different from what people might have read about there being an investigation into a suspected exchange of commercially sensitive information between market participants, which I think we'll maybe come back to. That comes out of the market study, so it's based on intelligence they got through the market study, but it's not part of it, and it's not the same thing as a market investigation. So since they aren't referring it for an investigation, all we can do is make non-binding proposals. So they set out in the report a number of proposals to the Scottish and UK governments, and indeed the Welsh government, for issues specific to Wales. And those really fall into 3 categories. So you have firm recommendations, where the CMA has identified issues that are specifically about the market and are very much within their remit. They've identified, second category, options, where there are things that are affecting competition, but those things interact with wider policy trade-offs that the CMA is not really equipped or really authorized to take into account. Planning would be the sort of prime example of that, where there are all sorts of considerations that go into the planning system. And then the third category was what they identified as factors that the governments might want to consider, but that were about issues that were entirely outside the CMA's remit. So it was kind of like, those are almost like FYI, here are some things you might think about, but without the CMA actually expressing a view. So the recommendations, the sort of firm category, are that council should be required to adopt new amenities in developments. There should be certain enhancements to consumer protections, and there should be establishment of a new homes ombudsman. And I know Fiona's going to talk about those. The options category include the adoption of existing private amenities, steps to incentivize build out through diversifying tenures and the types of homes that are delivered, councils being required to have local plans with clear, consistent targets that reflect housing need, the streamlining of the planning process to speed up projects, including improving council planning capacity and reducing the impact and timing effects of statutory consultation requirements. Again, Elaine will discuss those, so I won't get into detail on those. And then lastly, there's the category of things for governments to consider. Even though this is in the sort of least, none of them are binding, but this is the least binding of the non-binding categories. They are nevertheless some quite big potential interventions, and they are described as that in the report. So those are governments to consider ways to encourage self-build and custom-build homes, to increase publicly funded housing development on the basis that the report concluded that private builders just don't really have the incentive. They're not doing anything wrong. They're just not incentivized, and are unlikely to ever be incentivized to build out at the rate required to hit the sort of targets that governments have identified. The public sector taking an active role in buying and assembling land for development, and they also identified essentially some words of caution that governments shouldn't take steps that boost demand without addressing supply, because that just has unintended consequences and it doesn't actually get you more houses. Interestingly, the report in the end, despite the previous steps I was talking about, did not actually identify land banking as a problem. It concluded that where there was land banking, that was a sign of other issues in relation to planning or in relation to build out incentives that meant developers were sitting on the land rather than developing it, not because they were hoarding it per se, but because they either weren't able to build it out because of planning, or the incentives weren't aligning properly for them to build it out. So land banking wasn't an issue in and of itself. It was more of a symptom than a cause of problems.
Right. So quite a mixed bag of recommendations, and hearing what you're saying, that there's kind of that hierarchy, which is quite interesting. Um, and moving now to actually look at some of those, and to bring in Fiona, your experience from dealing with new housing developments, title aspects, the plot sales, dealing with sales to consumers. Maybe starting with um, the issue of the quality of new build homes that the CMA report addressed, um, and thinking about, there is a new homes quality code, there's a new homes ombudsman in place. So what are the problems that the CMA identified, and practically speaking, what are its recommendations, given that it sounds as though some of the things are already in place?
Well, the new Homes Quality Code, as well as the existing consumer codes, which we have, are voluntary schemes, and they're generally applied at the behest of warranty providers. What the CMA would like to see is a single mandatory scheme, so as to improve consistency in the routes of redress for consumers, and also to improve transparency. In terms of the routes that are available at present, the new Homes Quality Code does go some way to providing additional protections for consumers. It provides that a consumer has the ability to have a new home inspected by a suitably qualified inspector prior to completion, and to complete a specific pre-completion checklist. And then following completion, there's a requirement to provide after-sales service for at least 2 years, and to deal with issues including snags and defects as soon as possible. That's generally within 30 days, unless there's a specific reason for the delay, and to keep purchaser updated. The new Homes Quality Code does allow for consumers to refer the matter to the Ombudsman if they're not happy with what steps the developer has taken to remedy any defects. Another issue coming out of the CMA is the varying ways where someone can determine which developer to go with. So the CMA is recommending that there is a standard satisfaction survey that's sent to consumers after completion, and which house builders would be mandated to participate in, and then those key quality metrics could be shared with an independent body for public dissemination, rather than the different approaches that apply just now. That would improve transparency and ensure that consumers have access to reliable, comprehensive, accurate and timely information on quality. The extension of that current scheme is being looked at by the new Homes Quality Board. There's also a couple of other points that the CMA makes in terms of the sales, looking at the elimination of drip pricing, so that there's no additional add-ons for what would effectively be mandatory elements of a new home, and where optional extras are added, that there's transparency in the pricing of those at the time of someone coming in to buy their house.
Okay, so from the sound of it, it's not revolutionary, it's a tightening up.
Yeah, I think it would be a tightening up, and to make these schemes mandatory. As I said, at the moment, it does depend on what warranty provider perhaps a developer's with as to what scheme they'll be applying. So just so that a consumer knows that they've got a one-stop shop on that.
Yeah, yeah. And moving then to private management arrangements, and this is maybe where we should pause for a moment and just explain what we're meaning, because I'm always conscious that we've got a very mixed audience. So maybe just start, when we talk about private management arrangements in a housing development, what we're actually talking about.
So private management arrangements would generally be the management of an estate by a factor in Scotland. So that's generally applied through the deed of conditions, which would be in place on a development. And so that factor then charges the costs for the maintenance of the development, but also an administration fee for doing so. I think the CMA were concerned about perhaps some of the fees that are charged. I think that's probably largely applicable to England rather than Scotland, because in Scotland we've got the Property Factors Act, which imposes a code of conduct on factors, minimum standards to which they've got to meet, and an ability for a consumer to refer the matter to the first tier housing and property tribunal if they're not happy with the service of a factor.
Well, it's always nice to hear that being ahead of the curve, as it were, in having arrangements in place. And I think then, is there anything else you want to say,
Yep.
Fiona, before I go over to planning?
Yeah, so I think just picking up again on the factoring arrangements, what the CMA is concerned about is the imbalance of power between a consumer and a factor and those managing developments, and they're concerned that consumers can't effectively oversee management companies or easily change them. And often in Scotland, in the deed of conditions, there'll be a prohibition on changing a manager burden within the first 5 years. And there's also usually provisions requiring there to be a quorum of residents within the estate to participate in a meeting to do so, and that's not always straightforward to organise. The CMA is recommending the government introduces an enhanced consumer protection measures underpinned by a robust enforcement regime for households living under private management arrangements, and offering transparency, for example, by way of an annual report showing that the costs which have been incurred and reflecting the costs of managing the estate, and allowing people the ability to switch providers if they're not happy. The CMA says the households must have the ability to challenge charges or sanctions and not face significant barriers in doing so, and have a right of redress where appropriate. And the system shouldn't place disproportionate legal obligations or liabilities on households. And the new Homes Quality Code is seeking to address at least some of these points, including with the provision of an affordability schedule at the time that a reservation is taken, setting out details of likely management costs over 10 years of ownership. Another issue around the factoring arrangements is around the types of maintenance that are carried out. So in Scotland, again, we're lucky that we've got the Roads and Sewers Act, so these will be adopted by local authorities, but there can be issues around common space and the maintenance of that. The CMA wants to have a kind of standard position across the UK, and they are looking at having local authorities be required to adopt these sort of areas. But I think that's something that will possibly come through the planning rather than the kind of title process.
Yes, and by the sound of it, if the Scottish Government was to think about making changes, that would be a change to legislation. So that would be a slow burn. We're talking a good few years before anything would actually be changed.
Yeah, I think that would be a while off, but as I said, in Scotland, at least the kind of major issues around like the roads and the sewers are covered under existing legislation. So it would be to deal with other things such as I said, the open space. There can be play areas in that, and I think previously these have been adopted by local authorities, but obviously pressures on budgets and such. There has been a move away from that, and then liability would then lie with the residents in the development to pay the costs of that.
We used to, Neil, obviously do a lot of Section 75 agreements where the open space would have gone either to the local authority or then the Greenbelt Company, and you paid your kind of commuted sum, 20 years maintenance or whatever, and kind of passed it over, and then it just completely flipped to it all staying, within the development. So it'd be very interesting to see if we're going back to that.
I think that one of the things the CMA does say is that they recommend against embedded management companies, because if you have somebody like the Greenbelt who are taking on that, then obviously they'll have a degree of control on the areas in question.
Okay, thank you for talking us through that bit, Fiona. I'm now moving to planning. It feels a bit strange on Planning Live that it's taken us half an hour. I think we've shown remarkable discipline.
Sorry.
Saving the best to last. Saving the best to last.
It's good to get a mixture. And one of the things we know is that planning tends to be a focus for lots of external drivers. So it's actually quite good to have looked at the external drivers first and then say, okay, right, well, what are the implications for planning? So Elaine, on planning, the report does flag up problems with the operation of the planning system in England and Wales in terms of delivery of new homes. And those of us who read the planning press, well, to be honest, those of us just read the mainstream media, know there's a lot of problems down south. But if we're slightly selfish and focus on Scotland, can you touch for us on what the key planning concerns are in Scotland?
Yeah, unfortunately, unlike with Fiona, I can't say we're kind of way ahead of the game, on this side in terms of Scotland. It's interesting because, Charles at the beginning identified that there were 4 areas, of investigation, and planning wasn't one of them. But it's then become, the next stage, it's become one of the key concerns, I would say. And the report is really good. It gives an overview of the planning systems, in England, kind of Scotland and Wales. And it's identified kind of 3 primary concerns, and they're probably, the 3 primary concerns are probably the same, but slightly different, in each of the jurisdictions. But and these aren't going to be a surprise because, obviously we probably all live and breathe these. So first one, unpredictability, in the form of ever-changing policies and reforms. So this is some, and we're still living with the reforms that were brought in 2019, but still remember obviously the reforms from 2009, and we're still, it's that ever changing, and that makes it unpredictable. We've got NPF4, we're still rolling out those new policies on climate change, on biodiversity, carbon emissions. Out-of-date development plans was also identified as a problem, and with that unpredictability. And again, I'm old enough to remember when there were lots of ones where we didn't have up-to-date development plans, and then we did kind of get them back onto track, and then NPF4 has kind of derailed that a bit again because everybody was waiting for NPF4 to be adopted, and they're now obviously embarking on their new LDPs again. The second one, again, won't come as a surprise. It takes too long and it costs too much to navigate the planning process. And again, that's linked to the ever-increasing policy requirements, the lack of resourcing in planning authorities, the delays in statutory consultation responses, and dare I say it, the negotiation of Section 75 agreements, which is clearly not the problem of the lawyers, obviously, on that side. But a big concern, when it actually looks at the numbers, and it suggests that the cost of a planning application can range from £100,000 to £900,000. And then the lower land values that we have in Scotland, means those costs, impact, more up here. And interestingly, also highlighted the statutory pre-application process and the focus on affordable housing, all having specific impacts in Scotland, where they don't have, in England and Wales. And then the third one, and this I think is an interesting one, is that mix of competing requirements for planning authorities. So balancing having more homes against the policies that they've got to protect the green belt, and the countryside, so that bit, and we all know that NPF 4 says, you need to consider it in the round, and the weight to be attached to the policies is for the decision maker. And they flag up that the lack of national housing targets, that you get what you measure. If you're not going to have any targets, you're not necessarily going to get them. And then the lack of the presumption in favour of sustainable development in Scotland identified as a concern. And then they parcel all of that up and indicate that all of those together impact on SME house builders to a disproportionate impact, because they're dealing with smaller sites, but have still got the same delays and the costs and things. So those are the kind of three, as I say, the kind of umbrella three concerns that they've identified, none of which would be probably a surprise to you, Neil.
Or to many others on this. It seems like the same things we've been talking about with planning forever, I suspect always will. But have the CMA identified a magic bullet? What are their thoughts about what can be done?
Yeah, I wish that, they highlight that there's no single reform that will address it. We don't have that magic. So that they're suggesting that you should look at all of this as a reform package, and take it forward. And as Charles has highlighted, they're options. They're not, compulsory. But you would hope, we've all been saying these things for a long time now, and this is now, the CMA coming along and identifying them as well. So it's suggested that the Scottish Government might want to look at having more objective and effective use of housing targets to ensure that, that the targets are met. Now, you might remember, Neil, that was one of the recommendations from the independent report in 2016, that we should look at having national housing targets. And actually, we moved away from that. In NPF 4, we have the MATLers, so we have got the minimum all tenure housing land requirement, which local authorities, are being encouraged to exceed. But we've already seen East Lothian indicating that they don't have the funding, for that level of growth. So they're going to be coming in, underneath that. They suggest, obviously, that local housing targets should add up to the national targets, and they do make some suggestions about the methodology, and that could be a whole session on its own, but methodology about calculating the targets. Secondly, they suggest, more effective monitoring and enforcement of local development plans to encourage house builders to bring forward, I like this, to encourage house builders to bring forward successful planning applications and build new homes. I think all my planning applications should be successful. It just never seems to work out that way. And they talk about introducing, or dare I say, reintroducing the presumption in favour of sustainable development, where a planning authority is not meeting its housing target. So you remember the tilted balance, where you weren't meeting housing land supply, and then that could be that if you're coming forward with housing, then that would be sustainable development. And then thirdly, they suggest streamlining the planning system to significantly increase the ability of house builders to bring forward projects, kind of sooner, fast tracking, in principle approvals. And again, I think back to the reforms, and one of the suggestions was, if you had a site that was zoned in a local development plan, that could be akin to having planning permission in principle, but we moved away from that. We've been talking about streamlining and twin tracking roads construction consents and planning permissions and listed building consents. So again, they're suggesting, so as I say, it's not new, but it's interesting to have, a body like CMA coming saying, well, these things, we think if you were to introduce these things, these would lead to, an increase in the number of homes that are being provided. So improvements that they've suggested that could be done quickly, and Charles commented on it, being a bit more rigorous with the statutory consultees. There's been a review in England about how many, who should be statutory consultees. Should we be doing a similar review in Scotland? But then monitoring and enforcing the deadlines for coming back, again, will all of it experience where you haven't heard back from a statutory consultee, and that's holding up the planning application. So, should it be that if you don't hear back from them within the time period, that's a green light instead of a red light? So it's, put up or shut up type thing, you've kind of got to come forward. Not surprisingly, perhaps, they suggest that to help resource it, we're going to potentially look at increasing planning fees again. And of course, there is at the moment the consultation that's out from the Scottish Government investing in planning, which is about resourcing the planning system. And, you know, that's introducing things like, you have to pay for planning appeals and, you know, pay for your processing agreements and lots of things. But they do suggest that planning fees should be ring fenced, because that's the concern, of course, is that you pay for more, but it's not actually going into the resources in the planning authority. And so you're paying more, but not getting the better service. The two need to kind of go hand in hand. And they're also recommending that, you know, specifically supporting the SME house builders have, you know, better guidance, standardized policies, make your planning permission and principal approvals, you know, easier and simpler so that they can get forward on it. And then I think, as you know, Charles touched on, suggesting that we start to look for more diversity of housing tenure on the larger sites, government incentives to encourage people to deliver, you know, housing on smaller sites, and having, you know, the diversity of types of homes that they're building. So that's a very quick canter through everything that we should change in the planning system. Neil, you're on mute, Neil. Oh, I thought I'd gone deaf, but you're on mute.
As you were saying, a lot of things that have been discussed before, so it feels unlikely that anything much might change. Before we move away from planning, a question that's come in. What did the CMA mean by incentivise build-outs? Is this the same as NPF 4 Policy 16F3's reference to rewarding success with accelerated land releases where build-outs are faster?
I'm not sure I have the answer to, but Charles does, because Charles has just come off mute.
I'm afraid the policy reference is lost on me, but yeah, I mean, what they mean by incentivized build-outs is they're not referring to a particular policy. It's the point that I made about the point of a market study, which is about reviewing a market to see whether the participants in it are actually properly incentivized to produce the good that the market is supposed to result in being produced. So in terms of incentivizing build-outs, I mean, another way to look at it is to remove or mitigate disincentives. So everything that has just been discussed in relation to the planning system, those reforms, the CMA would have those reforms in mind as one way of incentivizing build-outs, because there would be there would be less cost and greater certainty for a developer. And all other things being equal, the CMA's economists will be of the view that if you reduce the cost of doing something, it will be more profitable for those cases that are marginal, and those marginal cases will go ahead rather than be prevented. So it's nothing as specific as a particular policy. It's really about are the market players who are in it to make money, is the market actually structured in a way that desire to make money matches up with the ability to actually do the thing that makes the money, and that's where you get the incentives.
Yeah, so one example might be if new policies are rolled out that create uncertainty, that might disincentivize a house builder bringing forward a site through planning. They might think that's just going to be expensive. I'll wait a few years till it's more certain, and then my application will go through more smoothly and it'll be cheaper for me.
And they've also suggested, a bit like developer contributions, that you should know the site diversity requirements up front, you know, because again, that will impact on viability if it comes halfway through the process. So, you know, there's that encouragement of, you know, when you're bidding for a site, what the developer contributions are going to be, then you can plan. And so again, it would be encouraging some policies in the LDP that would show what you're required to do in terms of site diversity for those specific sites.
So Charles, just to finish off, we've looked at the background, we've looked at the report itself. So what happens next?
So the study doesn't have teeth in and of itself. It doesn't place any obligations on anybody. But as Elaine mentioned, if the UK government, the Scottish government, and the Welsh government, if they mean what they say about wanting to encourage more house building, then they have this suite of recommendations and options and points to consider from the CMA, who have put a lot of work into reviewing the market. So I suppose it's a case of, if they mean what they say, they'll take up at least some of the things that the CMA has identified, and even where there are trade-offs, the CMA's view may tip the scales in favour of house building, at least in some cases, and possibly away from other policy considerations. But that's really all things for the government to take into account. The UK government has given an undertaking that it will respond to the report within 90 days. That's entirely voluntary. The Scottish government hasn't, but then the Scottish government isn't Michael Gove is in the UK government, and that's who asked for the study rather than the Scottish government. So Scottish government may respond. Certainly the letters from the CMA to the various governments indicate that the CMA is essentially, the market study team is essentially at the disposal of the civil servants, policy people, ministers who are responsible for these things in the different governments. So it's a case of whether they'll actually take them up on that.
But Neil, we don't even need, surely, Scottish government, to kind of come back. Some of those things planning authorities can be looking at, we could, and statutory consultees coming back within the timescale, moving forward if you don't have it. The bit that we talked about in terms of, balancing competing policies, that's for the decision making already do that. We've got a housing emergency, declared in 4, kind of authorities. We've got, the kind of shortage. You've already got the tools available for you to say, well, actually, on this, I'm tipping it in favour of there are good reasons for having housing, despite what it says about the Greenbelt policy. They've already got those tools at their disposal.
And then maybe just lastly, obviously, as well as the CMA having done its study work, that work has put the sector on the CMA's radar. So it'll be looking out for other ways to ensure competition is working. So we mentioned the investigation that it's undertaking coming out of the market study. So that's reported in the press as an investigation of 8 house builders, and that's under the CMA's power to investigate suspected breaches of competition law. And the CMA seems to have had intelligence from the market study that suggests that some of the house builders have exchanged non-public information. So in competition law terms, we'd call it commercially sensitive information on things like sales prices, incentives, and rates of sale. And that sort of commercially sensitive information that when it's shared, it essentially removes the uncertainty that's a prerequisite to effective competition. So that's why the CMA and other competition regulators don't like those sorts of exchanges. So the launch of the investigation there doesn't indicate any wrongdoing, but it does show the importance of all sorts of businesses. But I think now, particularly in the house building sector, understanding the importance of compliance, understanding the competition rules, and ensuring that people are trained on them to avoid getting into unlawful situations, but even just to avoid getting into suspicious situations. Because even if these investigations don't result in anyone actually being found to have breached competition law, these investigations themselves are not going to be pleasant for those affected.
Great. Well, thank you all. It's been very interesting for me as a planning lawyer, listening to the different touch points, as it were. As I said at the beginning, open invitation if anyone wants to follow up with Charles, Fiona, Elaine, and the various aspects. Always interested to discuss that through. Thank you all for giving up what might be your last working day before Easter. We will hopefully see you all back for the next Planning Live. We haven't finalised a topic and a speaker yet. We're not deliberately keeping you on the edge of your seat. It's just subject to some moving parts. So we will firm up on that as soon as we can. You can probably sign up on our website for it anyway, if you're a fan, because we can guarantee whatever it is, it will be good. And if it isn't, you can come back and have a moan at me. So we look forward to seeing you then. But even if, like us, or like some of us, you're working tomorrow, when Easter does come, have a great Easter, and we look forward to seeing you after that. So thank you again to the speakers, and bye everyone.
Bye.